In 1386, in the ancient town of Falaise in Normandy, France, a large crowd gathered to witness a shocking execution, a pig sentenced to death. The pig was accused of biting and killing an infant on the street and was therefore subjected to the same punishment as a human murderer. Its head and front legs were broken, and it was then hanged on the gallows. Before the execution, the pig was even dressed in gloves and a mask to symbolize the eye for an eye justice. This was not an isolated case. For centuries, courts in France, Italy, Switzerland, and other European countries have tried animals such as pigs, dogs, rats, locusts, and snails, accusing them of crimes against people, property, and even God. Scholars often categorize these animal trials into two types. First, secular trials, which typically dealt with individual animals that had injured or killed humans. Second, ecclesiastical trials, which primarily concerned pests like rats and locusts that caused widespread damage to crops, expelling them from parishes through religious rituals. From the 13th to the 18th centuries, Europe had a wealth of judicial documents and court records regarding crimes committed by animals. To modern sensibilities, animal trials may seem absurd, but at the time they were a concrete and official legal procedure. Judges, lawyers, witnesses, and executioners were all part of the process, and the cases were often based on local common law or customary law. On the same gallows, both humans and animals could be subjected to the same punishment for the same crime. For example, in December 1457, in the Savigny region of France, a sow with 6 piglets was accused of biting and killing a child. The 7 pigs were immediately apprehended and subsequently detained for a formal trial. The proceedings included a judge, plaintiff's lawyer, defense attorney, and several witnesses, just like any human murder case. Evidence showed that the sow was directly responsible for the child's death, while the piglets were deemed to have been passive followers due to their inability to prove guilt and their youth, and were therefore exempted from punishment. The sow, however, was sentenced to be hanged by its hind legs until death. A professional executioner was hired to carry out the hanging. This seemingly absurd process was taken very seriously. Both the judge and the prison guards treated the case with the same gravity as a human murder trial. The food and lodging costs for the accused pig were recorded in the same way as those for human prisoners. While the pig cases in Falaise and Savigny differed by location and time, they shared the same feature. Secular courts not only regarded animals as legitimate defendants, but also took great care in adhering to local judicial customs. In medieval and early modern Europe, animal trials often became public events. Livestock such as pigs, cows, sheep, horses, and dogs, if accused of crimes against humans, would be brought to court and appear as defendants, just like people. Sometimes animals' misbehavior would be noted in a way that was detrimental to their case. For example, a pig that loudly grunted in court could be considered unrepentant, which would lead to a harsher sentence. Some contemporaries compared these events to witch trials, seeing both as equally absurd forms of law. In 1474, in Basel, Switzerland, a rooster was allegedly accused of committing a horrible and unnatural crime, laying an egg. Folk legends believed that the egg might hatch into a monstrous creature known as a serpent beast or cockatrice, a mythical creature with the head of a rooster and the body of a snake. To prevent any danger, the court, in front of an audience, had the rooster and its egg tied together and burned at the stake. This case became one of the most bizarre and famous examples of animal trials. Unlike secular courts that tried individual animals, ecclesiastical courts often handled cases involving swarms of pests. Bishops and church officials would summon rats, locusts, or other destructive insects to appear in court, accusing them of ruining grain, fields, or vineyards. If they failed to appear, the court could issue a verdict of banishment or excommunication. Clearly, the pests would not actually show up in court, but the church believed that such religious summonses might, through divine power, cause them to depart. For example, in 16th century France, there was a famous rat case where the judge ordered the rats to leave the region of autumn. However, the rats' lawyer defended them on the grounds of difficult travel and the presence of cats, even requesting that the citizens lock up their cats to allow the rats to attend court in peace. After the request was denied by the citizens, the rats did not appear. In the end, they were formally excommunicated from the parish, which, as one can imagine, was absurd, since the rats would not actually leave. Sometimes, in a more formal attempt to notify the rats or insects of the eviction order, people would place pieces of paper with holy water spells or exorcism texts, coated with grease, into the rats' burrows in the hope that they would read and obey the summons. Such practices persisted in parts of Europe and even the United States until the 19th century. Medieval people had limited knowledge of pests and diseases, and the chemical control methods they could think of were few. Sprinkling weasel ashes or cat bath water on fields, or castrating captured rodents and then releasing them to warn others sounded just as superstitious as the church's exorcisms and curses. For people in Europe at the time, resorting to religious trials was simply a divine version of pest control, essentially seeking supernatural protection. In 1750, a man and a female donkey were brought to trial in France for the crime of bestiality. Ultimately, the man was sentenced to death. However, the female donkey was unexpectedly acquitted. The reason for this was that many local residents, including even the clergy, signed a petition on behalf of the donkey, stating that it was well-behaved and virtuous, the most honest creature in the world. Based on this, the judge determined that the donkey was a passive victim of a violent and abnormal human and should not be punished. It is worth noting that such character assessments were more common in trials involving livestock. This is because, in the medieval mindset, domesticated animals living with humans were believed to have a better understanding of right and wrong. If they appeared arrogant or ill-mannered in court, they were often regarded as deeply guilty and unrepentant. To modern people, animal trials may seem absurd. However, from the 13th to the 18th centuries, this practice had its own logic in European society. Many medieval farmers spent hours daily with their livestock, observing their choices, emotions, and individual differences. Some even believed that animals had the ability to make moral judgments. However, this close interaction, in which animals were tried like humans, coexisted with a cruel reality. Once an animal was recognized as a criminal, it would face the same bloody consequences as humans for harming people or damaging crops. With the rise of industrialization and modern slaughterhouses, the farming model underwent dramatic changes, and long periods of close contact between humans and animals gradually disappeared. While modern society does discuss animal protection in legal terms, we are still often surprised when new discoveries are made about animal intelligence. This indicates that we remain unfamiliar with their true abilities and behaviors. In contrast, some medieval societies gave animals personified moral responsibility, likely because they lived closely with these livestock, seeing a more multifaceted side of them. Looking back at those absurd animal trials in the Middle Ages, they at least show that people at the time, within the frameworks of law and religion, made considerable efforts to view livestock or pests as beings capable of moral choice. This also demonstrates a certain empathy or projection between humans and animals.